pronounce his name well, because I don't know how to pronounce his name well.
Nobody knows.
And Maciej is now based at Nicolás Copernicus University in Poland after many years in Colombia. So he's our local speaker to some extent. Maciej, you will see later, is a specialist of the topic and has had a really central role in forming the panel. And to my right, Dr. Sebastian Espinosa, who's from Ecuador and at the moment working with the university in Quito, a specialist of investment law and constitutional law, which you will see relates to the panel we had 2 days ago. I have to mention another colleague, Dr. Lorenzo Cotula, who couldn't be here physically, but certainly helped us and work with Maciej on the topic. So you may wonder what we are going to talk about. Our title is slightly mysterious and a bit complex. International investment law and international dispute settlement from the below. So what are we talking about here? We're actually talking about what some could call the rest of the world. We also take a sort of critical, post-colonial, and certainly perspective influenced by subaltern studies. Well, you all know about subaltern studies, so we've all read the work of Fanon, Said, or Spivak and Chakrabarty. We also take some critical distance from these subaltern studies or post-colonial studies, because we feel, at least I do, and we'll see if my colleague absolutely share that, we feel that we are to some extent in a post-colonial world with some instances sometimes of reverse colonialism with new hegemons, and we're thinking in particular about China and India, obviously, and this has had an impact on our field and investment law in particular. We're also looking at the question of modernity and how modernity questions these categories of civil society, communities, subaltern, subjugated, and so on and so forth. We also look at these people not only in the global south, but also in whatever is called the global north, as I personally distantiate myself from Spivak's perspective, who thinks that subaltern term can only be used in a sort of, post-colonial environment. We talk very much about the sort of transnational capitalistic elite, and we could probably talk as well about a sort of localized subjugated class. So we'll see whether these sort of categories are applicable and how. So without further ado, I'd like to give the floor to Maciej so that he tells you how the project was developed and how it relates to a larger project we have together.
Okay. Thank you very much, Leïla. Of course, I am delighted to be here. Thank you very much for the organizers and all of you to survive to the very last panel. Our proposal, which was presented by myself and Lorenzo Cotula, was about the working group or academic forum working group, which was constituted last year. And the title of that working group is Local Communities in International Investment Law. Unfortunately, Lorenzo was not able to be here, as Leïla mentioned. Our group has brilliant names, and we were able to convince Nicolás, we were able to convince Leïla, we were able to have Gloria Alvarez, Jesse Coleman, Ibironke Odumuso, and Ladan Mehravan. So the big names, as you know, the people who really work on the fields of the local communities. Of course, right now we are struggling as usually the group which is dispersed all over the world. So finding the time to meet and pushing the agenda is quite challenging. But I would like to tell you why this subject is within the academic forum working group. There was no direct demand from the states in the UNCITRAL working group 3 to precisely investigate that subject. However, of course, the local communities shows that problem of the asymmetric nature of the treaty-based ISDS. And as I can show you that, for example, in the after the 37th session in April 2019, the UNCITRAL Working Group 3 report mentioned that there is a need to ensure the participation of third parties in SDS, including the participation of the general public and local communities affected by the investment or the dispute at hand. Also, the same paragraph says that the matter of the legitimacy of the ISDS system, it would be important that affected communities and individuals, as well as public interest organizations, be able to participate in ISDS beyond making submissions as third parties. So we of course struggle how to fit our work within that the mandate of the working group, which is restrained to procedural issues, as many interpret. But of course, the local communities touch upon those big problems which were asked by the states to investigate. So of course, the problem of the countermeasures, problem of the third-party participation, also the issues surrounding the rights of local communities connects with the key concern of the working group, such as consistency, correctness, predictability of the dispute settlement decisions, and of course, the local communities problem also touch upon the procedural issues, procedural efficiency, as we perfectly are aware that each amicus curiae, each participant will prolong the proceedings. And of course, we would love to have, and we are working how to include those third parties or local communities within the system. Also, we cannot forget about the negative aspect of that it will prolong the system itself. It will make the most costly the proceedings. It will make those arbitrators to decide not on investment, but on environmental issues of human rights, etc., etc. So apart from enthusiastic idea that those local
will be widely distributed, because what we want from you, from the society of the experts, to comment, to critique, because the idea is to produce a policy-oriented paper, which will be later presented during the working group UNCITRAL forum for the states. So it will produce something which is academic, and it's basically with no response. It will not be taken into account. If you want to produce something for the policymakers, it should be top 15 pages. So that's kind of the challenge which we have. And I think that's enough from me at that point. I encourage you to follow what we are doing, although we are not publishing that. When we will have something, we'll distribute that among the academic forum members and also to everyone who is interested for the comment.
That's fantastic. Thank you very much. So as you understood, our panel is part of a bigger picture. You're all invited to comment, to critique, to adapt your suggestions, because eventually we modestly aim to impact and probably impact sort of policy making. So as you understood, we talked about civil society and we talked about community. Community is a word which is going to come very often in the discussion, but what is a community? My colleagues are going to present their perspective, but for the very least, we can agree that a community is a sort of social unit, a group of living entities, showing a commonality of values, perhaps, but also interests, maybe, or places, norms, or customs. This community creates a sense of identity, possibly togetherness, belonging. So we have to question these concepts as well to understand what exactly we try to do here. We may also allude to, well, a legal philosophy school, right? The communitarian school, which, as you know very well from Sandel to others, have sort of insisted on this community-based approach to law and international law as a critique of the liberal legal order, insisting on concrete rights. And this has been used as well by populist regime and leaders. So you have the pros and cons, so the critique of liberalism, and at the same time, a possible instrumentalization of the community. And that, again, is something which is going to come into play in our discussion. Without further ado, again, I'd like to give the floor to Nicolás to reflect upon this non-state actor, civil society community.
Thank you, Leïla, and I'm pleased to be here. Thanks to the organizers and see Jose Manuel here, so, and Enrique as well, so, and everybody else from SIEL who has made it possible. And it's also great to be here in Colombia as well. A SIEL happening in Colombia and South America is great news for everybody. So what I want to do very briefly is to try to answer a question that actually, or Maciej posed, or at least kind of alluded to, which is like, why states were not interested in bringing communities into the conversation, you know, or into the ISDS system. So working group 3 states are the masters of treaties. States are the masters of investment treaties of the ISDS regime. Sorry, they're the masters of public international law, but still, you know, the demand for local communities' participation has not really come from them. So why is that? And I think the question is more interesting if you see that most local communities, when they participate in ISDS, pertaining to amicus curiae, or at least through, you know, the way they appear on media, the way they talk about the dispute, they normally talk in favor of the state. They normally provide reasons or arguments or facts that support the case of the state. So it sounds a little irrational, quote unquote irrational if you want to. So from a neoclassical economic point of view, your interest should be there. You want to win the case, and these actors would normally help you to win the case. So why is it that? So to answer that, I think we need to challenge the political economy and international investment law. I think we have been looking at that incorrectly. And I borrow a category or a taxonomy from Nancy Fraser to try to explain why I think actually states and investors agree pretty much on a lot of things. And I was going to say pretty much on everything, but maybe I was going a bit too far. But I agree on a lot of things. So we get a regular investment law textbook, and starts with the idea that states and investors, there are tensions between them. And investors are, you know, they want to invest, but they are in need for some additional protection. And investment treaties and ISDS are there to provide that additional protection. So there is some commonality of interest, but very basic ones. Other than that, there are tensions. So I want to challenge that, and I will say they agree on a lot more of that. And then communities, and then of course the way we define local communities can be open up to a conversation or a discussion. Then those are the ones where actually at that particular point a big intention with states and investors. Now, if you eventually agree with me, then we will need to completely rethink international investment law, because we mean that we got the political economy incorrectly. So what do I think it's where is the tension between investors and states? Of course there is a tension, but generally speaking, the tension is pretty much about distribution, of conflicts of distribution. Distribution not only of benefits, but also of costs and risks. Yeah, so I mean, states want to get most of the benefits and very little of the cost and risk, and investors want pretty much the same. They want the benefits, but they don't want to run with the cost and the risk. So the distributional level, yes, there is a tension. But then Nancy Fraser also talks about representation and recognition. For sake of time, I'm going to bracket representation. We can talk about that later if you're interested. But then there is a question of recognition. And it's here, I think, where investors and states are pretty much on the same page. The question of recognition is how you see the world, how you see the organization of society, the way of life, whether you have certain common background ideas about political organization, economic organization. And I think here, most states in the world, most post-colonial states, or as I still, they're quote unquote colonial states, and foreign investors are pretty much on the same page. They all think that there are parts of the world, parts of their territories that are not modern, they're backward, they are traditional, they are slow, and they need to bring capital from abroad to bring that areas and those territories into modernity. So that is kind of the agreement, you know. And I mean, of course, you could say, well, you need foreign investment. I think Rodrigo was making the point, you need foreign investment to promote the SDGs. And I guess pretty much everybody will agree that we all need better hospitals and better education. But how you do it is a big question. So I think most states and most foreign investors agree on how they want to do it. But communities, they do not. So if you go to, I don't know, to the Guajira here in Colombia, and you talk to the Wayu community, they would say, of course, we want better sanitation, we want more water, we want better education. We actually don't want coal extraction that is very disruptive for our way of life. And this is the tension. I think states, and you see this, for instance, in the Ecuador and Colombia, both Ecuador or Gray Star And the Colombians at the very beginning were on the same page. They thought that mining was a good idea. They thought that gold mining was a good idea. The Ministry of Mines thought that, the agency thought that. And it was the community, both in Betas, California, and then in Bucaramanga, who had a different. Now, that's pretty much my main point I want to make here in this first part of my presentation, is that we need to reconsider the political economy, and then the question is what that means for international investment law for ISDS. If it's not like the state against the investor, like an intention, but rather the state and the investor together, creating problems and tensions for local communities. And then, of course, how we define communities, again, a question, but I think that broadly speaking, we can see that there is a tension here that is worth exploring. Thank you.
Thank you so much, Nicolás, for this very thought-provoking, I think, first perspective. So, on the contrary to what we think very often, there is a sort of collusion, if I understood well, between the state and the investor, and the communities would be left aside and not necessarily in the picture when we decide about investment and investment law. Belén, I think you have an illustration from the perspective of international environmental law.
Thank you, Leïla. Just to be clear and for full disclosure, I'm coming from the intersection, my research is at the intersection between international economic law and international environmental law. So basically, my approach would be to communities from that perspective, in particular in what concerns environmental protection and climate change. I've got 3 claims. The first claim is the ISDS system is not fit for purpose from this perspective. So 2 main points: asymmetrical, that was clear, that was really clear from the previous speakers. And second, well, the communities are really not represented there, mediatized by the state, which is a classic problem of international law. So therefore, when we come to the question of climate change in particular, we can see that there are these different tensions, right? So, we have different ways of responding to that question. I know that, of course, climate change, it is a global phenomenon. Because of transboundary effects, we cannot differentiate really between global south and global north. But if you look at the reports and also the different statistics and evidence, the global south will be more impacted. So therefore, there is a relevant role for international investment law there in either exacerbating or mitigating climate change. So now, communities. I think from the environmental law perspective, communities, sometimes there is a reductionism, and we interpret communities as local communities. Of course, clearly, local communities affected by environmental damage in different contexts, not only in the energy context, even though my research at the moment focus on just transition, but in different environmental realms. So that is one of the problems, right? So usually if you look at Latin America or Africa, so the communities are indigenous communities or Afro-descendant communities. Personally, I don't know if we can include them or not. I think there is a huge problem around finding what are the communities, what are the relevant communities. And also there is a problem there in terms of legal standing of communities, which ties with the question of procedural issues. So different ways in which we can solve the problem. Of course, the international investment law system has internally tried to address the issue, in particular when it comes to in climate change law, with different provisions, different environmental exceptions, etc. Is that enough? But in both cases, clearly, we don't have the time to go through the different cases, and we've got new BIT models. Some of them are more advanced than others. For instance, the Morocco BIT model is quite advanced in areas, and there are specific BITs like Morocco, Nigeria, which try to address the question of the environmental question and the climate change question. There is a panoply of climate change provisions in the recent treaties, and I think that Polonia and Hungary, they have done already the taxonomy of the climate change provisions, but are those enough? Do they guarantee the participation of the communities? And the response is, well, it's not enough. So I'm working on the ground, for instance, with some of the main associations, like in particular those that represent indigenous people, and they issued representation there. Who is represented there? And this morning we had a very interesting discussion about the rights of nature, which I think are overcomplicating, in some cases, the question of who represents the communities, right? And for instance, for them, is not enough. And the main criticism towards the agreement towards the system is even if you've got very, very good environmental law, clause provision or climate change provision, there's a risk of fossilization of the environmental protection. And that's, of course, we know already the refugee problem, etc. So it's not enough, but the question is, what are the solutions there? Different solutions have been proposed. A platform which is survival, they are working on having an indigenous people's approach to investment and to investment disputes and resolution. There are different proposals about including specific provisions. Perhaps you're aware of Marcus Poyerski's proposals about having specific indigenous people's provisions in DITs. But the question is, well, in the end, boils down to the procedural issue. Well, transparency rights, which are a generous concession by states, right? The third-party rights, they were a response to the bottom-up pressure. But in the end, it's a concession, it's a discretionary concession. So that's it. I have said this thing more. Yes, that's what I
will say more. But Belén, you raised many interesting issues, and in particular, as I said, the procedural question as well, the question of representativity. So Sebastian, from your perspective in Ecuador, and we know that Ecuador, massive cases, Chevron and all the many lawsuits related to the case. What would you like to add up on the committee in particular?
Thank you very much. It's really a pleasure to be here in front of you today and being among this fantastic panel. And Ecuador is very interesting for many reasons in the context of the international investment law and the construction and reconstruction of the relationship between investors and states and non-state actors. And in the case of Ecuador, I would say I would use the term of Nicolás, legal imagination, not only by investors or for the protection of capital, but also the legal imagination is being translated and being used by the civil society to contract against investors, I would say. And all this legal infrastructure that has been set as a decentralized set of interpreters to uphold economic interests is also being used now by civil society to limit or to gain space against investors. And they are using different international legal regimes or substantive provisions in order to shape their relationships with investors. In the case of Ecuador, in the first place, I think that one of the main outcomes was the Constituent Assembly, in which there was approval provision apparently targeting ISDS. On the basis of inflation, the Constitutional Court, at the request of the President, initiated the demonstration of the bilateral investment treaties, and the Constitutional Court found these ISDS provisions not in conformity with the Constitution, and on this basis, the President initiated a procedure to terminate these bilateral investment treaties. Also, Ecuador announced in 2008, based on this same constitutional provision, the exit convention. All this process, which was backed by the Commission, auditing all the system and also the arbitration awards, it was composed for big personalities like Carlos Valerias, Osvaldo Bumino, and also representatives from the civil society who determined that actually ISDS was against the Constitution, was against several principles of law, and as I said, it's determined the demonstration of these treaties. And soon after, in 2019, there was initiated a request for reinterpretation of this Article 422. It was requested by the President of the National Assembly, and they wanted to actually to change the conclusion made already by the Constitutional Court in these rulings, and they wanted to re-enable ISDS. Since this constitutional provision states that it is prohibited to surrender sovereign jurisdiction to arbitral venues in case of commercial and contractual disputes, they wanted to say that, and with all reason, they wanted to obtain the outcome that investment disputes are neither contractual nor commercial. And here we could see a very rich encounter of different actors from international law professors like Nicolás Perrone, Catalina Pistor, Sonaraya, who were battling, let's say, the conformity or the non-conformity of international investment treaty with the Constitution, and also other pro-ISDS actors who also send very sophisticated submissions. And at the end of the day, with all this participation, also there was a very strong opposition of the Confederation of National Indigenous, and the Constitutional Court avoided to interpret that on the basis of a formal request. And afterwards, we have seen in the last years an uprise of writs of protection invoking directly international legal instruments. Since the Constitutional Court in 2021 stated that international instruments on human rights are directly applicable, most of the local communities are going to first instance courts, and for instance, claiming on the basis for the Paris Agreement or the Escazú Agreement and so on, the limitation or violation of their rights. So now we have an infrastructure of legal interpreters applying directly international law on the basis that they are related to international instruments of human rights. And it is interesting to see how these judges are dealing with these massive dockets of legal submissions, and also from scientific evidence. And since now, with all the technology, it's very easy just to request for just for the Zoom link and sending them to studio, it's very colorful now that the motivation is related to this kind of extractive industries. You have people from all over the world just stating or trying to persuade the judges. And for instance, in the case of a copper mine in Cotacachi, it's an indigenous community in Ecuador, and the judges stated that there was a violation of the Escazú Agreement to public consultation, and Ecuador ratified this agreement in 2020, and this environmental license was issued in 2014. So, of course, the government, so the investor in this case, were arguing the violation of legal certainty. Also, in the area of the Amazon, it was used the parliament to suspend immediately the gas flaring of the petroleum wells immediately, on the basis also of Paris Agreement. So we see now great infrastructure of actors acting from inwards, not to change the treaty, for instance, but mitigating, in this case, to determine or limit the relationship that we have with investors.
Well, thank you so much, Sebastian. You've almost responded to our last question. What's the impact on international law, investment rulemaking and dispute settlement? But you raised a number of issues, and you all understood that there are plenty of non-Equatorian actors in Ecuador, including when we talk about amicus curiae, because Ecuador, as many other countries, receive a lot of advice, foreign advice from different parties. So shall we talk now about amicus curiae, because this is often portrayed as the solution to represent these communities.
Yeah, I will be very briefly. I will be very brief because better experts here to talk about amicus curiae, but just to say that, for example, within the work of our academic forum group, we have to be fair, we have to somehow respond and assess amicus curiae. I don't feel that this is the solution. So, and I'm talking only on my behalf, not on the behalf of the group, but because we haven't reached the moment of thinking about the possible solutions. But when we will be discussing the possible solutions, I don't think that amicus curiae is the silver bullet or the possibility to make those unheard, invisible communities visible. Why? Because also this is a big business. So we are having amicus curiae participants who are playing to their own goal and not especially for the local communities. I mean that there are a lot of law firms which are interested in just submitting amicus curiae to make themselves visible, to make them recognized in the region, to make them new clients, etc., etc. And when I had my first presentation, I mentioned that amicus curiae will raise the costs of the proceedings. So we are here having that, unfortunately, the balance, if to open doors more broadly for amicus curiae, which for me it's not the solution. This is something which we have today, so this is what we are using, because there is not better solution to make those invisible communities to be present during the proceedings. But for the long term, for me, it's not the solution.
Yeah, sorry, thank you. I mean, I just want to give you an example, just to, I started saying I wanted to explore the idea of the West States from one communities in ISDS. If you take Bear Creek and Peru, it's very interesting. If you, instead of just looking at the word, you look at the amicus and how both the investor and the state responded to that amicus. So that amicus is, I think, is quite good for a good number of reasons. And one of those reasons is that it kind of provided a lot of facts that were not so clear in the file before the participation of the amicus. And not all of the elements were in supporting Peru as the legal position of Peru in the case, but also denouncing the lack of institutional support of Peru, the abandonment of the community, and certain questions like, that the domestic legal regime was not good enough to protect the community. In addition of saying that the investor did not behave in a nice way, did not translate into Aymara, and all the things you are very, already if you read that word. So how the investor and the state reacted to that, that's the interesting part. So the investor said, of course, this is in my favor. You cannot blame me for Peru, for the fact that Peru did not, implement the right domestic standards. Actually, so the local community or the amicus is telling me that I'm right. You cannot impose sort of global obligations that not even the international community has decided already. You cannot impose them on me. So it's not my fault. And then Peru said, of course, we agree with the local community, but by the way, all these things that they're saying about us, they're not really that. And one of the things that I found very interesting in that case is that the expert that Peru support provided said that the problem was that the investor did not educate the community for the community to understand the benefits of that investment. Now, of course, the community, and if you read anthropological work that was done later, although, of course, the community understood the implication, that's why they opposed the project. But the more interesting part is that they say, it's not that we don't want quote unquote development, going back to the SDGs point, is that we want investors that come, and this is in the Puna region, as you know, in Peru, we want investors to adapt to local traditions, to adapt to the way we live here, instead of imposing that to us. So I mean, what I find very fascinating is that how the state reacted to the amicus curiae. And that of course goes back to the question, why is it that states don't want amicus participation, or what kind of participation they want there? Yeah, so I don't think it's about educating the community. I just wanted to end with that.
Excellent. Belén, I think you have a reaction.
I think, my reaction is from working on an amicus curiae for the last 1 year, and that I think also with the remarkable scholars and academics working on Ecuador, right? And really, of course, that was, we were following the case really, and in the Ecuadorian jurisdiction, in the US jurisdiction, and I think that, well, my reflections from that experience, right? What we tried to do is to provide a meaningful amicus curiae, and I think that's one of the points there. That is a meaningful amicus curiae. So are you helping the judge? Are you helping? Who are you assisting the amicus curiae? We were in contact with the communities, right? And it was our intention, at least. Then, you know, governments can use the amicus curiae in a different way to help the communities with their claims, right? And it was extremely difficult. And it was all pro bono. I mean, there was no intention there to make a name. And it was one colleague of environmental law, Don Anton from Australia, leading the group. But I think that my reflection about amicus curiae is like, of course, there will be different uses of amicus curiae, but from an academic point and helping the cause, helping the communities, why the point is making a meaningful amicus curiae. And also reflection of the essence of women. Because on the ground, many communities don't like to engage with the essence of women. It's good that it's telling that they're very effective application. But I think that there is a critical counterpoint there. I mean, I'm in favor of this, that's why I have worked on implementation. Obviously, I see it as a very good tool, right, for advancing communities' rights. But I mean, we need to acknowledge as well from the ground this kind of opposition.
Very interesting. So Sebastian, from your perspective, what's the meaningful dynamic is really knowing that we worked a lot with constitutional judges and other justices in the country?
I mean, it is difficult to say because in the case of the proceedings which are entertained by the Constitutional Court, you have justices who come mainly from academia, and they have a very sophisticated legal education, and I mean, I think that they interpret instruments or treaties on human rights in a very expansive way, and I guess that they consider this kind of amicus depending on the person or the group who is issuing amicus curiae. For me, it's very difficult to think in the judges of first instance, since there is a very clear path in the constitutional practice in Ecuador, and I think that is also shared in the region, the global constitutionality, for example, and the very binding nature of the obligations of the Inter-American Court of Human Rights, but not all the international pronouncements have the same weight, and you see how judges are interpreting I mean international relations. It doesn't matter either they are treaties or advisory opinions or declarations in a summit. But it's striking how do they select the report or the amicus that they are going to apply, and they are swimming in an ocean of legal opinions and also scientific evidence, and they are giving effect to several reports or to several documents that actually don't have even a binding nature for the states, or they don't recognize individual rights. So I think that this undermines the authority of the state, for instance, in the sovereign management over natural resources. And also, I think that this is a form of colonialism because views are being imposed in the way that we manage natural resources. We are constraining our own tools of development. For instance, we are going for a referendum in August to live under the ground. The oil in the Yasuni field, it's going to cost almost $2 billion. And we are requiring these funds for health, education, and so on. So I think that if you have all these infrastructure in the affairs of international law, of course, the most popular outcome is to say that we are constraining investor rights. But at the end of the day, we have to pay bills and we have to fund social programs. And in this case, I think that, yeah, amicus curiae and the participation of transnational actors in this kind of proceedings has gone too far. And I mean, the interpreter of the Constitutional Court has not done enough to clarify the scope of this instrument.
Thank you so much, Sebastian. I'm sure we'll have questions from the audience about this sort of neo-colonial intrusion through the advice of experts, which is something we see a lot in our field anyway, in the making of treaties and norms. So let's get back to the remark of Nicolás on the education of the masses, education of the local communities, and this should be done by the investors. So what can we say about this other non-state actor corporation, and what sort of role do they play with these local communities in the business and not in the business?
Shall I start? Yeah, go ahead. Now that's a great question. Thank you, Leïla. So I think that most investors who are in the mining sector or in the oil and gas or critical raw materials, they know by now that they need to get along well with the communities if they want their business to go well. So I think this is something that has, at least when you talk to people who are in the business, they understand this. Then the question, of course, is what that really means in practice. So again, I refer to this. So after the Bear Creek, Bear Creek and Peru was not just an ISDS case. It was like a massive demonstration in the Puno region. I ended up with mobilizations in Lima, with people getting killed, and was a serious problem that is not very well reflected in the world, perhaps. And one of the things you see there is that what the community really wanted is not non-investment whatsoever, but that the investors would embed their project in the local community and not the other way around. So, so people from the Puno University went there and did interviews of what people were actually hoping for, expecting for. And this has a lot to do with the scale of the project. Those of you who are familiar with Peru and Bolivia, you know that mining has been there for a long time. It's related to colonialism, but in a way was also appropriated by some of the communities. So the socavón, and there are certain practices that are part of the community by now. And those practices work well with like medium, small scale mining. But once it's large scale mining that in 30, 40 years is going to get completely deplete the resources there, it's kind of impossible to embed that into the locality. But that's basically is taking the mountain, and removing it from it forever. And even affects their identity for the mining communities, for the local mining communities. They know that after 30, 40 years, there won't be mining there anymore. So I guess this is there's a tension there between large scale mining and other possibilities of extraction that can be embedded with the way communities have been living for the last 300-400 years. So I think that large scale mining corporations have still not managed a way to solve that problem. And I'm afraid I don't have a solution here, but I just think it's good to identify the problem and to acknowledge, I think that ISDS is not going to resolve that either. And that's a problem, of course.
Of course. Thank you so much, Nicolás.
And very briefly, what I believe is that companies and corporations will take into account the voice of the local communities, which will be, if it will be beneficial for them. And to do this, also, I am really glad for the work of Nicolás, who was pioneering that subject 10 years ago, 8 years ago. Right now, this is the subject which appears on the international level, but 10 years ago, it was silent. So just bringing the subject on that international level, talking here and making conscious people that this is the problem. I'm not saying that that's the solution, but that is a step forward. And then companies realizing with their human rights and PR departments, checking pro and cons, will simply realize that it's maybe better to not to have that very black PR and not to be engaged in the situation which may affect their perception on the international level. So my solution for now, even if I don't have that, make that problem heard and make that problem like visible for the social, for the international society, for the consumers. Don't forget about the great power of the consumers who are somewhere in the France or London, checking if that was, if that coffee was cultivated by not affecting the frogs or the animals. And this is the price which we can pay, paying a little bit more for that kind of friendly environment. And if we can do that for animals, for sure, we can do this as well for the human beings, for the indigenous communities, for the local communities. But simply that was not, the problem was not on the table. And I think that just bringing that on the table and making that as a problem for the companies, they will realize that simply it's pro and cons, and this is simply the math, that it's better for them to be engaged and to be more pro communities. It's not only this, it's like if we have big projects like here in Colombia, Hidroituango, basically you cannot find a solution there because you have so many communities affected that you can satisfy 70%, but still you have 30% which are against. But at least bringing that problem, this is one step forward to have that solution.
For sure. Well, I'm less optimistic maybe than you are, working on human rights and businesses for a long time. You know, this is unfortunately sometimes we keep thinking. I think the environment argument works sometimes, but unfortunately the human rights and labor does not. And we see more greed and more exploitation everywhere. But I might be very negative. Belén and Sebastian, of course, reactions.
Yeah, I think that is, I mean, this is quite interesting, but if you see that same case, right, running from the Ecuador, right, and the Sarajevo case before the International Court of Human Rights, you can see the contrast between the different regimes, so to speak, right? Even though the Ecuador is considered one of the successful cases in terms of environmental concerns, how they were, taken on board by the IIL. But I think there is that tension. I mean, and multinational corporations, to be honest, right, so are not only those located in global, in the world, and actually, it's actually. But anyways, so the point there is about multinational corporations. I think that there is an instrumentalization as well of the rights of communities, sometimes environmental rights, that's linked to reputational risks. Right? For instance, one of the critiques about the just transition in the energy sector, or the just transitioning broader terms into low carbon societies, like now is the mantra of multinational corporations, and under that umbrella you can. Of course, there are good programs for educating communities about that, about what is a just transition, but obviously there is a tension there.
Yes, I want to highlight stress the formal and informal mechanisms of participation, how they influence policy and judicial decisions. In this case, the very open participation in the possibility to intervene through different mechanisms, as I say, just through video conference, brings to the table actors who were not foreseen before. And also a lot of information that has to be scrutinized, that has to be discriminated, I would say. And From this perspective, I would stress that all this legal infrastructure may be thought at the beginning for advancing economic interests, and all this exposing of good governance and rule of the international rule of law, and also legal certainty and so on, that have linked free trade and good treatment of investors with, as I said, good governance, also may cover the claims of civil society or local communities through other regimes. So we have more interpreters who are not only looking through this economic perspective, but also to all these kind of legal obligations arising from international declarations or commitments, not necessarily international treaties. So in this case, I mean, from the perspective of investors, it will be very difficult to understand what is the frame governing their relationships. It is not only concerning investment policies or investment laws or investment regulations. It may deal with a great array of commitments. Moreover, when, for instance, in countries like Ecuador, as I said, it has been interpreted that international instruments in human rights can be any kind of pronouncement made by international organizations related to human rights. It can be an opinion, it can be an advisor, also a report, and it has been misused, I would say. So if we take into account that sustainable investment is part of a sustainable development goal, and we just fragmented the SDG that we have to apply, I think that it will come against the common interests.
Very interesting. So before we give you the floor, we'd like to briefly conclude to some extent. So what do you think is the impact and indeed what these local communities have brought or not to the making and implementation of international investment law?
That was harsh.
Or you must think about it.
Yeah. Honestly, I'm happy that we are having that discussion. So, the problem is that the solution, that the immediate solution, that this ISDS doesn't work. We have to just destroy it and build a system which is equal, fair, etc., etc. But that's not so, maybe not also the solution. So, like we with our academic forum group have that problem that we have to present the solution within the system, which is procedural reform, not the substance, even if we believe that substance should also be, and there's a lot of issues which should be reflected. So I think that that subject should be reflected within the reform, because if not, the reform will be crippled. It will not be the legitimate change, and it will not be the change of the system which we all expect.
Fantastic. Okay.
Yeah, I just think that the role of communities, and like looking at the importance of communities, like trying to understand what was happening to communities in many of these ISDS cases, at least in Latin America, but probably as well in other parts of the world, it has shown how ISDS and investment just how closely related they are to extraction and to fossil fuels. And if you are really moving to a clean economy, like a green energy or a green transition, that we should reconsider the regime, like the Paris Agreement is asking us to. And I'm glad that there are certain processes are going in that direction. I think more needs to be done, because yeah, I don't think ISDS and investment is just a policy mechanism, just like an ally of extraction. And this in Latin America has very lot of problems. I mean, if extraction needs to happen, it needs to happen in a different way.
Yeah, I think that the main contribution, I mean, there are two for me. One is to the visualization of environmental conflicts that are linked to some of the investment projects. It's very interesting. If you have time to check the Environmental Justice Atlas, you can see environmental conflicts and then the impact in cases of investment growth. That's one, I think, more from it. policy, political perspective. From the legal perspective, I say they are bringing to the consideration the question of like, should we fight the system from within with the tools that we got, like state counterclaims, for instance, that are being considered now. But again, that brings us back to the question of like, who represents the communities? Are the states really reproducing people? But I think it's very interesting. Also, more environmental carve-outs, climate change carve-outs in treaties, and so on. And I can see that coming from the communities. But the question that they pose is like, shall we fight the system from within, or shall we propose a radical change? And where I see the proposals for a radical change, or at least for a different approach, are from these platforms, like from survival, right? Indigenous peoples really. I mean, debunking this rosy idea, tinted the idea that indigenous peoples are like kind of like, you know, they don't know how to advocate for their own rights. And I think that's the part where I don't know if the system will have the capacity to accommodate those emerging voices.
That's very interesting. I'm sure we're going to talk about that during the discussion. The paradigm shift we mentioned yesterday in international clinical and investment world. So I really come from the people. Sebastian, on the impact.
Well, I would say that I haven't said that. I think it's not a good idea to consider the role of domestic law as source of creation, application, and enforcement of international law. And yes, to determine the scenario platform where all these rights are being deployed and normally are clashing. And I remember, and I think it was very interesting in one of the panels of constitutional law, international law, and the importance to show the way that sovereign powers have been exercised through non-discretionary manners, following the procedure and applying the obligations then from the Constitution. Now we have this concept of the constitutional law in Latin America of obligations which go beyond the constitutional provisions. So I think that this is one of the main challenges for the state to determine which is the scope of its obligations concerning all these commitments.
Very interesting. Thank you so much. So it's time to open the floor to questions. We have many questions. Fantastic. I see 4. The first one, yourself, and then all right. Go ahead.
Thank you very much. It's super interesting.
Oh yeah. Sorry, you have to move the mic.
So I want to repeat that it's super interesting. Thank you very much. It's super interesting. I'm really thought-provoking. So I'm gonna ask questions and make a couple of comments. But full disclosure, my comments come from the experience I had in my previous life. In my previous incarnation, I work a lot with communities, environmental, indigenous communities, in training and bringing cases of public interest. So first, I think Nicolás, Nico, probably you will be surprised. I agree with you on this. I think you're actually right, but I think it's a bit more complicated than that, because the triangle that you identified, state, investors, and communities having different standing. I mean, they're basically on the same page, state and investors, thanks to these treaties, and communities in another standing, is not unique of investment treaties. It's something that happened in our domestic systems a lot. And let me bring you the example of environmental impact assessment. Throughout Latin America, we have that all the time. So state receives an environmental impact assessment from a company, and the rights that the company has and the right that the state has in the whole process, they're completely different from the rights that the community has. And in fact, the community, they don't have rights. They have some kind of diffuse interests. You have 10 days to comment on environmental impact assessment that is 4,000 pages and 10 tons of paper, for example, without technical expertise. So I think you're right to point out that they are not at the same level. And in that sense, states and investors are on the same page. But I don't think that's unique of investment treaties. It's an issue of communities' rights vis-a-vis states and investors, and it's an issue of property in the end. Because the other thing I want to say is that we are assuming, there's another thing that we are assuming that communities are all on the same page.
No, of course not.
And from my experience, I had cases where there are actually communities, indigenous communities, with competing interests. One, they were for a project, one against the other project, and they were fighting on that. So my third comment would be on that is that when you are defending indigenous communities or communities in general, it's funny because now the system is so much, when the system was just starting, to use investment treaties, it was part of the defense toolbox, you see? So, for example, a couple of cases that we use investment treaties as a way of deterring a project that we didn't want the project to happen. So they wanted to flood the whole region in Patagonia, and we said, look, what can we do? So we start having some people buying pieces of land at a very cheap rate, so they would have to expropriate, and they were protected, and were foreigners doing that. So we created foreign investors in a place, not to try to say, what, you want to do that? Okay, we're going to bring a case. We started buying shares in companies, in Canadian companies that they were doing in. So my point here is that I think you are fundamentally right on the point that communities, they are on a different level than states and investors in this. But it's not, unfortunately, it's not a problem just of investment law, it's a deeper problem. And also when communities learn about this, they can use, it's part of the guerrilla toolbox. I still remember that when we signed the first free trade agreement with Canada, Chile didn't have, we have a general environmental framework, but the regulation to apply that law, it was not enacted, and the government didn't want to enact it. So we went to the using, you see, here I think my morale on this is that the state gets a free pass too often. It's very, I mean, I'm telling you that the investors, they do this wonderful, but states get a free pass very, very easily. So we were finally, the Canadian government convinced, they said, you want the free trade agreement with Canada, well, pass the regulation first. And then we signed the free trade agreement. And as environmental organizations, we were very happy that the free trade agreement, it sounds weird now, no? That we used the free trade agreement to improve the environmental regulation in Chile. But this was 25 years ago.
It still happens. It still happens. Do you want to react to that?
Either way, what do you prefer? You're in charge.
Yeah, well,
You're in charge.
please do react to that.
Very quickly, very quickly. So maybe you'll be surprised, Rodrigo, and I fundamentally agree with you, but I do think there is a detail or two. I think it's different when it comes to domestic law or international law. You know, because the way what happens under international law is that the state, as we know, is only one state, only one voice, and it's the one that is, you know, in breach of international law, and that is operated by people domestically to also promote their interests. And I think ISDS has been mainly used to promote interests different from the ones we were talking about. Generally speaking, exceptions apply, of course. Now, let me explain you briefly why I think it's different. With domestic law, we are all part of the same democratic society. There are elections, there are political parties, you can organize, you can change laws, eventually change the constitution. What happened in Chile where there was the idea, okay, we're going to reform the constitution, we're going to start from a blank page. All the people who negotiated the treaties got together and said, you do whatever with the constitution, but don't touch the free trade agreements. And I think that explains why it's slightly different. People, and this is what I didn't talk about, which is representation, people are closer to domestic law, closer to environmental impact assessment to the agency in Chile as compared to free trade agreements, compared to international economic law. They're further away from that, they have less control over that, there's a democratic problem there. So that's why I think we need to be more careful with international law as opposed to domestic law, because you, me, paying taxes in Chile, we have more control over domestic law as opposed to international law. So we fundamentally agree but I think the political economy is not exactly the same.
Super interesting. Thank you so much, Nicolás. Now we have our question, Ines, and then 1, 2, 3, 4.
Yes.
Great panel, thank you. Couldn't be a better end to the conference. So I very two hopefully brief interconnected comments. Just basically asking for your reaction. The first one is sort of the emphasis on the making or remaking the law, and by this I mean the reform process. Maciej drew attention to that, and he's at the academic forum, I'm in the academic forum, I'm also an observer at Universidad, so I just want to share a very brief observation. There are about 40 to 50 observers. We talked about the participation proceedings, but observer status in the Universidad meetings, working group 3 meetings, if you actually pay close attention, there is next to no representation by any group that purports to represent the civil society at any level. In any context, local communities, other sort of segments of the civil society. There is plenty of foreign investor or investor lobbyists. There's quite a few council representation. One of them is represented literally by the former council to ExxonMobil. There are a lot of academic institutions, some of which are critical and more against the status quo, CCSR being one, because you mentioned Ladan, and maybe Lisa can be also mentioned. There was Client Earth that disappeared after 2018, 2019. I don't know what happened to them. There's nothing. This is number one. The connected observation, a comparative observation. I have secondhand experience with another committee under the auspices of UN, which is the UN Commission of the Peaceful Use of Outer Space, UN COPOS. Roughly the same number of observers. I would invite you to look at the configuration in that setting, and you would be positively surprised. We talked about local communities, but I want to, at the risk of maybe diverting the discussion a bit, I want to talk about another segment of civil society, which is younger generations. And I say this concretely on the basis that there is a very, very impressive establishment, which is now 30, 35 years old, called the Space Generation Advisory Council. They represent literally the younger generation with an actual active observer participation of the UNCLOS, where they represent younger generations, basically representing the absent in the generational sense. So the geographical aspect, just for a second, imagine, it's not hypothetical, imagine an actual representation of not just local communities, but also younger generations in the context of the future of ISDS. Because when we talk about mines, sustainability of resources, etc., there are those the generations that don't exist yet will be probably more, it will be more impactful for them than it is for the people who are alive today. So just two little bits of observations made it fruitful. I'm curious about your reaction.
Very, very interesting. I'm conscious of time. We have 15 minutes. I just want to ensure that everybody has a say. Please go ahead.
Thank you very much for this wonderful panel. So first, I'm sorry, yeah. Okay, so I'm gonna repeat to this super panel. But this, I have first one question for Maciej, and it comes from Belén's reflections, and is here the panel you talk about civil society. But this is a very wide term, right? What is the civil society we're talking about? And then I noticed that there is different levels of discussion. Some of you talk about communities, like it's so wide, and especially because we have this civil society that is also part of the global north, that are also technocratic, that do not represent the people that perhaps you aren't thinking about, indigenous communities, peasants, right? So I'd like to have clarification on the scope of the project, right? Second question is, Nicolás, you mentioned how a lot of time there is the similarity between the state and the investor, right? I was wondering whether it also could be because of conflict of interests of civil servants that they use they have this revolving door, right? So they're in the government, for instance, representing the state, defending it, but they know they'll be there for 4 years and they're thinking ahead, okay, perhaps I'll get a position there, right? So whether it is because of conflict of interests that we're not looking at. And finally, I know who would like to answer this, but there is a big challenge of communities, I will use the term communities, participating in amicus curiae, and is the term of cost, because more documents, more hours for the panel, more cost for the state, right? So how are we going to challenge that? And also another barrier, language, right? Cost and language. Thank you.
Thank you so much. So we take our 2 additional questions, one in the back and.
Really stimulating into the conference. 2 quick points. The first one, I see that you're focusing on the global south and on the indigenous communities, or at least it seems like it in the presentation. And you also look at cases like Clayton Biltong because they really fit the pattern in which you're talking. Okay, good. Second was on the point about ISDS. Are we assuming that if ISDS was eliminated, that these local communities would have no voice? Because I'm not sure that's not true. And in fact, you might lose the international community's attention, as flawed as it is, if you take it out of ISDS and put it in the rest.
Thank you so much. Last question, and maybe we do some of the wrong.
Okay, thank you. Congratulations.
We are glad that you are repeating that.
Excellent panel, very interesting. One quick question which comes to my mind. We're talking about mostly of the distributional issues. However, the trend, as I see it, is to focus on representation and recognition, particularly in this part of the world. You have the Escazú Agreement, the IIL Convention 169. My point is, if those instruments work in terms of recognition and representativeness, I think there will be no investments because that first process delays the investments, and therefore investors might not be willing to wait all that time. So it's a very difficult issue. So I don't know if you have any comments on that.
So much, very interesting. So I don't know who wants to respond to what. I will something. Yeah, please.
Well, Belén, you start.
I think that we need to be careful about monolithic approaches on both sides. So the communities are very different. The heterogeneous group, and I think the challenge there is really finding a good classification really about the communities. And then in terms of the state, also it's a monolithic, representation, but there are different interests, right? And I assume that also when it comes to multinational companies, it's the same. I think that we do not oversimplify the problem, but we have limited time to focus on very particular issues, and I think everyone was coming from a different angle. I think that, of course, it's not only about indigenous people, but it is about different communities, right? So again, brings us back to the question of who are the relevant communities, right? So, and I agree with Rodrigo about environmental impact assessment. There is another process that we have not mentioned that is also related to investment project, which is a free, prior, and informed consent of indigenous people. And I think that, well, there are very interesting interfaces there, right? And with regard to Frank's question, I need to be very careful because I don't believe that if we get rid of the ISDS system, these communities will gain more visibility, right? So I would claim that's the opposite. We need to find a balance. Yeah.
I will try to be as brief as possible. So going to be honest, many thanks for your comments. This simply reflects how those communities and their interest is invisible. But I would love to follow that discussion later. Regarding Enrique, of course you are right. We struggle, no, we haven't struggled so far within the group, but of course there's a problem of definition. Just briefly to say that we didn't want to refer only to indigenous people because that's closing many doors. Although we have with indigenous people the legal framework and it would be easier. Of course, we understand local communities as local communities with including indigenous people. We have international instruments like Convention on Biodiversity, Article 8J, I think, which reflects local communities and indigenous people. So we try to take that approach, and there is when you look for the comments on that convention, you have the list. What does it mean, local communities? I'd love to follow the steps of Lorenzo, who in 2007 wrote that local community means basically geographic proximity. Also, like with the Peasants' Declaration, the vulnerability will be that key issue, and like we have in indigenous people in the local communities, that is self-identification, something very important. And then moving to the your comment, we do not close our eyes on other continents. Of course, Latin America is we have a lot of examples, but we decided at the very beginning that we should look also at Europe, Asia, so it is not restrained geographically. And very briefly to the magistrate Linares, what I believe, even if we are doing that within the UNCITRAL, I would rather think about the solution like Ruggi did in his work, that there is no silver bullet, it should be few pillars, so enforcing domestic regulations, because that would be the solution. If the states do their job, there is no point of strengthening the international regime. But of course, it should be multi-level. It is not that ISDS will solve the problems. Really, I don't believe in that. But within the group, this is where we are looking for solutions.
Yeah. Well, yeah, thanks for the questions. They're great questions, better than the panel I have to. Yeah, much better, probably. So very briefly, so Enrique, I think I agree with you. Yeah, so the state is not a black box, and there are different actors within the state that have different interests. And in fact, probably not every actor within the state is on the same page with the investor when it comes to remuneration questions. So yeah, that's all. The point is taken, and maybe we need to dive into the structure of the state, and yeah, that's good. And I think, Frank, yeah, of course, I mean, Belén is probably the best case for this, isn't it? Better than the Latin American cases. Also because of the way the decision and the idea about the value, the core values question, and how the environmental panel acted there. And I mean, you know how you check you have the award, and then you look at Canadian scholars. Canadian scholars were saying that the award got Canadian law wrong. At that level, I know what, a couple of them. And the majority of that award is based on the idea that they misapplied Canadian law. While Canadian lawyers were saying that actually you are misunderstanding Canadian law. That's ISDS. I don't know. That's what sometimes why you don't understand ISDS. But I haven't seen any Canadian environmental lawyers saying that there's other way of interpreting Canadian law that is incompatible with the decision of Canada. So it's like everybody was in favor of that. So it's like, yeah, there is Gabriel Mining and Romania. I think it's another interesting case. You have amicus in that case, and again, that amicus is saying, yeah, the investor did a lot of bad things, but also Romania did a couple of bad things. And then Romania again is having to answer the community in the proceedings. And of course, again, most of the amicus is in favor of Romanians' points in the case. But there is a wider denunciation. So communities also take the chance to denounce how they've been treated by the state. You know, for a long time you promoted the project, you didn't care about me, and now because you are being sued under ISDS, you remember that I exist. You know, I can bring, you know, some explanation, some reasons for your that support your case. And finally, I just want to say I'm very conscious about that problem. And I think it's a very difficult question. I mean, unfortunately, I would prefer Latin America not to live from extraction, to live from something else. But I mean, every economist you talk to that's serious in their work, they acknowledge that that's not possible from day one. So that transition would require that we still extract resources, and then the question is how we do it in a way that is also, bringing everybody on board. I'm just going to conclude saying that Jose Manuel knows this. We did an event here at Externado in 2018 where we brought some people, community leaders, and asked them these questions. And I asked exactly this question, and they said, we would be better off dealing directly with the investor and take the state away. So we negotiate with the investor how they're gonna do extraction in our territory, and then they go and negotiate with the minister of mine, whatever they need to negotiate with them, and not the other way around. Because they come together, state and investor, and we have very little leverage there. But if the investor comes first, we negotiate with the investor, no states. This is incredible. We didn't expect the asymmetry, but it's true that the asymmetry is worse. It's the state plus investor against. So maybe that's the answer. I don't know the answer that the Ministry of Mines wants to hear, the president wants to hear, but maybe that's the answer from the community side.
So there are 2 points there, and I think this is important for the project as well. So about the concept of justice that is, I think, underpinning the community's place, I think it's quite important. You mentioned, I think, distributive justice.
Yeah.
The focus, I think, but there are different concepts of justice. I mean, I think restorative justice in many cases is the underpinning concept there. The claims. And then there is the right of the future generations, which ties in with the principle of intergenerational equity or equality. So I think that those are also underpinning in some cases the claims. And what's your question, your point?
Exactly, because your point was about the youth, right? The young generation, which are somehow sort of community as well, and would like to take it.
In Europe, yes, they are a different, distinctive community, right? Because they have different claims and different right in environmental law and climate change.
And they have impacted ISDS in Europe greatly, energy charter and so on and so forth. So a lot of food for thought. I would like you to join me for a round of applause to the panelists and to you as well.